accepting submissions here in the Sassower.
No.
You made a submission.
It's the statistics and other information that will make the testimony.
You'll be able to ask educated questions. Please. You are informed, right? So I know what it is.
My name is Elena Sassower. I'm director and co-founder of the Center for Judicial Accountability, Inc., a nonpartisan, nonprofit citizens organization that for more than a quarter of a century has documented the corruption of judicial selection, judicial discipline, and the judicial process itself. This includes the judiciary's corruption of the system of attorney discipline, all aspects of which it controls and which it uses to protect and insulate from accountability politically connected attorneys and to retaliate against judicial whistleblowing ones. I am also privileged to be the daughter of two such judicial whistleblowing attorneys. My father, George Sassower, was disbarred by a February 23, 1987 order of the Appellate Division 2nd Department for violating court orders requiring him to acquiesce to the court's cover-up of lawyer larceny of assets of an involuntarily dissolved corporation, assets which have yet to be accounted for by the court nearly 30 years later. My mother, Doris L. Sassower, was indefinitely suspended by a June 14, 1991 so-called interim order of the Appellate Division 2nd Department without reasons, without findings, unsupported by a petition or by any hearing, as to which to date, nearly 25 years later, there have been no findings, no hearing, no appellate review. New York's court-controlled system of attorney discipline, as it currently exists, is 35 years old. And it has survived because no one in a position of power or influence has confronted the proof of its dysfunction, corruption, and politicization. It is because I knew and understand that the attorney disciplinary system cannot survive an evidentiary presentation, that I contacted the Office of Court Administration to find out whether hearings would be held, public hearings, because this commission, the Commission on Statewide Attorney Discipline, was, until the third week of June, inaccessible. It had no phone number, no website, no way for the public to contact it with the information born of direct personal experience and to furnish it with the documentation that it would need if it was going to conduct a legitimate, honest review. And it is to the credit of now Chair Hosier and prior thereto Chair Prudenti that in response to my inquiries on the subject, that they threw up a website and announced these public hearings. I have handed up, and I ask you to open the file folders so that we can examine together what I think Mr. Zoderer identified as something of concern to him, and that was the statistics. So the very first page are statistics. Now, I will tell you that the Office of Court Administration does not make these statistics readily available. They're not on its website. They're not really anywhere. To the extent you can find anything, you can get from the fourth department its statistics, which are part of its annual report, and the first department has its statistics in its annual report at the back. I have given you the page from the New York State Bar Association's annual report put out by its Committee on Professional Discipline, and this is the most recent from 2012. Let's just take a look at matters disposed of, okay, for 2012, all right? Now, we talk about the grievance committees, but the fact of the matter is the grievance committees are sham entities.
Yes.
They don't really exist. They're not operating as committees with all their membership, because most of the complaints that are filed with the committees are going out at a stage where none of the committee members have ever seen those complaints.
Right.
They're being processed by staff. All right? Now, if you look at the statistics here, you see, and because of lack of time, I don't want to dwell on it, but if you see that the three departments, the second, third, and fourth departments, are dismissing between 45 and 52% of complaints they receive are rejected by them as failing to state complaint, which means, of course, that they are purporting that the allegations, if true, wouldn't be misconduct. All right? But look at the first department. It's only 11%. That's too great a range. There's something wrong. How do you account for that difference? Now look at the next category, dismissed or withdrawn. First of all, that category makes no sense, correct? Because a complaint that's dismissed is very different from a complaint that's withdrawn. They should be in separate categories, but
Yes.
they're bunched together, okay? But if you add up those two categories, and what you see in the first department is that it makes up for the statistical difference by dismissing 63% of complaints. It doesn't identify the reason, but they're being dismissed, okay? Plus the 11. The cumulative statistic is that between 74% in the first department, 63% in the second department, 69% in the third department, 75% in the fourth department are being dismissed at the outset.
Right.
And the truth of it is that those